Do you want to use this one?
Whatever. I don't care.
Okay.
She said it's better for the online people.
Okay.
I don't.
Okay, because
I get along with this one.
okay, because they told me that the vice is it you?
Yeah, I'm vice. Yeah.
Okay. Yeah. Wanted the headphone, the headset microphone, but the same for us.
Margarita, what shall I do?
What I was telling you before, because in previous year, you tend to move while talking, okay? Which is perfect for the audience here in the room.
No, I said I behave if I stay.
If you behave to stay and you speak there, no need for an additional mic.
Okay, I behave.
Again, for the audience it's perfectly fine, even without the mic, but we have people connected online. That's the reason
No,
why
I behave. I behave.
Okay.
For change, I behave. But did you change now the name?
Yes.
Yes.
Exactly so. Manfred Price, Professor Element, Element, look for the tickets. Is it fine?
It's okay. It's okay. I'm sorry. I'm sorry.
No, it's not a problem.
Yeah. I behave.
But if you want to stand up, just look at me. I will bring you one mic. Okay.
For the discussion, it might be better if I stand up. Then I see.
Okay. For the discussion, you stay here.
Yeah, but this, I'm small.
Okay. So for the discussion, I will bring to you the
Let's see.
mic.
I can see. I can stand here.
Otherwise, I will bring the one to be handled.
It's easy.
Is it? Okay.
No, I get along.
Otherwise, with that one, you can move and go everywhere without any issue.
So let's do it.
Let's do it. It's easier. You don't have to think about it.
Please try to talk.
Yes. Okay.
Okay. Now it's on.
Okay.
It's okay.
Dear colleagues, please take your seats that we can start in time. They do not behave.
I think, Manfred, if you start, they will.
Jan, I don't want to be too cruel. Okay, can we start? Let's do it. Dear colleagues, good morning. In yesterday's plenary session, we had an excellent assessment of the status quo, of the problems of the non-work and work complex. Today, we want to shift the perspective a little bit and want to look at labor law. Labor law, as you know, is a child of industrialization, and when it was made, the reference point was the Fordist model, meaning people working in huge factories, mainly full-time, almost exclusively male, and so on and so on. This, of course, does not fit anymore to our problems of today. First of all, labor law, from the very beginning, has left out many areas which were considered not to be integrated into the market. And secondly, the world of work, as you know, has changed dramatically. Technological innovations, problems of carbonation, and so on and so on. We have a fragmented and a segmented workforce. And there are many areas where labor law has not kept up and where people still do not have the kind of regulation they would need to have decent work. That's why we do what we do this morning. We will have, by the three speakers, an in-depth analysis of three examples. The first example will show how labor law has not yet succeeded to keep up with technological change. It will look at platform work and in particular at the impact of algorithmic management. Also focusing on the gender implications. The second example will be an example of different types of care programs and how labor law might be able to cope with it. And finally, in the third example, we will cope with mandatory work for recipients of social assistance benefits. In all three examples, the main question will be whether and how labor law might be possible to shift this kind of work in a way that it is meaningful and satisfactory for those who are performing it. The first speaker will be, and now I have to look, will be Luz Rodriguez Fernandez from the University Castilla-La Mancha. Do I pronounce it correctly? Hopefully. And she will talk about new challenges for labor law in the age of platform work and gender inequalities. Luz, the floor is yours.
Good morning, everyone. Many thanks to ADAPT to inviting me to this session. Many thanks to Professor Weiss for the presentation. I'm delighted to be back addressing you all, so let's go. I think I can do it.
Well, we had already this morning the technological problems, you know. My philosophy is never use PowerPoint. It has neither power nor a point, but nobody is following me, so we have these problems.
Yeah, sorry. Okay. Okay, I can start. Okay, even if platform, look at that, yes, it's here, okay. Even if, or even though platform work occupies a significant place in debates about the future of work and the work in the future, we know very little about its scope. There are hardly any statistics from official bodies around the world on the number of platform workers and their profiles. This creates a kind of paradox. While platform work is a topic well known to researchers, social actors, and governments, we have very little information about the real protagonists, the workers and the platforms. In the European Union, we have a pilot survey from 2022 that can help us learn some data about platform workers. 3.0% of total European Union population aged 15 to 64 work on platforms. Most platforms workers are men, and this is important. They are approximately 30 years old. They have a high level of education. The majority of platform workers are engaged in delivery platforms, and the majority of platform workers earn less than 1/4 of their income from this work. So we can agree that this is not a majority sector in our labor markets, but for some years now, we have been talking about platform workers, and we already have a European directive regulating, you can say that, the working conditions, and an ILO, International Labour Organization, convention and recommendation on their working conditions is about to be adopted in 2026. So the first questions, the first considerations for today's debate are two. First, why does a relatively small sector of workers attract so much interest? And two, what makes working for platforms so different that it warrants unique regulation? For answering the first question, I believe we can put forth three answers. First, platform workers, especially those working for delivery platforms, have made their precarious situation visible on our streets and in our cities. Second, and for me this is important, from my point of view, there has been a significant academic activism in the sense that many academics around the world have focused on the precariousness of these workers and the need to protect them. And thirdly, and most importantly, because these platforms appear in our labor markets, they have challenged the concepts of employers and employee on which we have built most of the institutions of labor law and industrial relations. Well, how legal systems around the world responding to this challenge to our concepts of employer and employee? In addition to the directive and the draft ILO convention and recommendation, there are many other pieces of legislation on platform work. I have studied in my book 23 laws or drafts of laws. In summary, all these legislative initiatives follow two models or approaches. First, The distinction between subordinate work and self-employed work is maintained, but it's made easier for platform workers to be classified as subordinate workers. This is done, as you know, mainly by presuming the existence of an employment relationship. Examples of such regulation we have in Spain, Mexico, British Columbia in Canada, as well as the European Platform Work Directive. The second approach is the distinction between subordinate work and self-employed work remains, but platform workers are considered to be self-employed workers who are entitled to some of the rights of subordinate work. This involves expanding some rights associated with subordinate work to self-employed workers in the platform economy. Examples of these include France, of course, Chile, and Ontario in Canada, as well as the European Platform Work Directive and the proposed directive on algorithmic management in the workplace, which was approved by the European Parliament, as you know, on 11 November. To this end, to expand or to extend some rights associated with subordinate work to self-employed platform workers, we are inventing new terms, new norms, or ways of defining who is a worker. In the Platform Work Directive, we have platform worked, but we have also person performing platform work. This is a new name to know who is a worker. And the directive uses this name to extend to all platform workers the rights related to algorithmic management and the limited right to information and consultation and the right to collective bargaining. Second, in the new proposed directive of algorithmic management at work, this is very difficult to understand, but we have worker as a person who is deemed to have an employment contract, not to have an employment contract, is deemed to have an employment contract, and a solo self-employed person. And again, this proposed directive uses these names to expand to all kinds of workers' rights related to algorithmic management. And finally, and I was there in June in 2025, the draft ILO convention uses digital platform worker. And again, digital platform worker is used to expand to all platform workers' rights related to algorithmic management of work. So, as you can see in all these definitions, the main aim is to all of them is to expand to all kinds of workers the rights related to the algorithmic management of work. So my second question and my second answer is what is so different in the platform work, what makes platform work so unique, and therefore deserving of a unique regulation is, in fact, the algorithmic management of work. And when I was researching in the European project GD Power, I learned that to address the challenges this poses for workers, it is necessary, and this is my point, to graft data protection law onto labor law and then data protection rights into labor rights. And then, at this moment, with the expansion of algorithm use into many other productive sectors, this grafting of data protection law onto labor law is spreading to workers across all kinds of companies. So something that was born within platforms is now present far beyond them. Time is pressing. Yes, it's really pressing, and I cannot go into all these rights relating to algorithmic management of work that we have incorporated into labor law from platform work, but I would like to make a few points in two directions, data and algorithms. With regard to the collection of workers' data, The use of personal data is not something unusual that happens only in a marginal number of companies. The collection and use of personal data have become so commonplace that I believe we must emphasize that we are facing a new phase of capitalism, which Julie Cohen called informational capitalism, and which, according to her, is distinguished by the fact that we have moved from a manufacturing-oriented economy to an economy oriented principally toward the production, accumulation, and processing data and information. So the use of personal data has become a fundamental component of contemporary production models. Consequently, several scholars, as you know, conceptualize data as a new raw material or even as a novel form of corporate capital. So given this, I believe that as a labor lawyers, and we are speaking about labor law, we can ask ourselves two questions. The first one is, does the employment contract, the employment relationship, of a similar relationship of exchange of personal labor for payment legitimize the capture of all kinds of personal data for workers? This is my first question. I ask this question because we are talking uncritically, this is my vision, uncritically about how to resolve the challenges posed by the collection of workers' personal data. That is, without first asking ourselves, labor lawyers, whether the employment contract legitimizes the indiscriminate collection of workers' personal data. I believe it doesn't, but I leave open this debate for later. Second question, would it be possible to understand that workers have a right of ownership over their personal data? This is my second debate open for later. If so, I believe that, and that is my point, that through collective bargaining, workers should be financially compensated for the collection and exploitation of their personal data to make companies more competitive and richer. The second aspect to be analyzed in the use of algorithmic for work management, which you know was originally the hallmark of platform work, is the algorithmic management itself. As you know, the use of algorithms and artificial intelligence systems has countless impacts on employment and work. But I would like to focus in one and maybe in two. I don't know, maybe in one or two, it depends on the time. The first question I would like to highlight is the asymmetry of information that the use of algorithms and artificial intelligence system creates between companies and workers. While companies are aware of the use of these IT tools, how they work, their purpose and their effects on working conditions, working know nothing, almost nothing about them. Sometimes they are not even aware that they are subject to algorithmic management. That is why the response, the answer of legal system has been magic transparency. That is, workers should be aware of whether they are subject to algorithmic management, the basic operation of the algorithm and artificial intelligence system, and the impact this has on their working conditions. And the instrument for this is the right of access included, as you know, in the Article 15 of the General Data Protection Regulation, GDPR. However, this configuration of the right of the magic transparency is, for me, insufficient. Why? I learned all of this when I was researching in GDP Power project. Firstly, because workers are unaware that they have this right. This is not seen as a right for workers. Secondly, because data on algorithms and artificial intelligence systems are often difficult for workers to understand, and for me, and for trade unions. And thirdly, and most importantly, because individual workers don't have enough power to really influence the algorithms used to manage their work. So the right to transparency must be collective, not only individual, but also collective. This means that workers' representatives must be aware of the categories of data that the companies collect, the algorithms or artificial intelligence systems they use, how they operate, and how they affect working conditions. Only worker representatives, and we are all labor lawyers and know that, only trade unions and workers in general, workers' representatives can have enough power to influence the algorithms that companies use to manage work. Unlike the GDPR, this is the path taken in the Platform Work Directive and again in the proposed directive on algorithmic management in the workplace. However, I believe that this is not enough. It's not enough given that in most countries, the recommendations made by workers' representatives following periods of information and consultation are not binding on the companies. That is why I believe that collective bargaining, at least collective bargaining, should be used to establish co-governance between worker representatives and companies on data and algorithms. One example is just a collective agreement in Spain, you know, and its algorithmic committee where workers' representatives and the company agree on everything related to data capture and the algorithms used. And I have time to speak about the second impact, my final impact. It's not the last impact, but it's my final impact about algorithmic management. Oh, sorry, it's here, gender impacts. Thank you, Professor Weiss, yes. The second impact of using algorithms for work management that I would like to highlight, because I have been studied many hours, is that they include algorithms and artificial intelligence systems include biases and discrimination, and here we are particularly interested in gender bias and discrimination. To sum up, there is no reality without algorithms free of bias and discrimination, and a reality with algorithms full of bias and discrimination. Gender bias and discrimination have always existed, but now they fit into algorithms and are more difficult to combat with our anti-discrimination laws. And this is because decisions made using algorithms and artificial intelligence systems are presented as objective and neutral because they are product of mathematical formulas, and it is really difficult to make people understand and demonstrate that a mathematical operation, a mathematical formula can contain bias and discrimination. So we have a very good anti-discrimination law, but it is difficult to use these anti-discrimination laws against the discrimination of algorithmic management. Second, gender bias and discrimination happen for three reasons. First, because of asymmetry in the data. That's it because there is much more data on men than on women. Second, because programmers are mostly men and only a minority of women program algorithms and artificial intelligence systems. And third, and this is the most important thing, because the social conceptions from which programming is done reflect the views and options on reality of men, typical of a male-dominated society. So it is, for me, it is essential to review the data that feeds the algorithms to ensure that they not contain data that could lead to bias or discrimination. It is essential to review the decisions made by algorithms to check that they don't give rise to bias or discrimination. It is essential to educate programmers in fundamental rights, in our constitutional rights, in the right to equality, and finally, to have multidisciplinary programming teams. That's all. I'm on time. Thank you very much for your attention.
One thing right now, I fully agree with Luz as far as her expectations on the regulation of data is concerned, and as far as the improvements in relationship to algorithmic management are concerned. But I'm asking myself and yourself, is it really realistic in this time of omnibus philosophy, where under the label of reduction of bureaucracy, everything is reduced and deregulated? And don't forget, the proposal of this directive on algorithmic management originates so far only from a committee of the European Parliament. But the initiative, as you know, is with the Commission. And the Commission, as far as I can see, Frau von der Leyen and the others are not willing to do this in the near future. We can talk about this. But now we have the next speaker, and the next speaker is Professor Yiran Sang. I hope I did pronounce it correctly. She's coming from the famous Cornell University in the United States, and she will talk about the legal boundary of work in the US public care system. Go ahead.
Thank you, Professor Wiss. I think this is thank you all for being here. I really appreciate this opportunity to share with you my research project looking at care, looking at the moving boundary of legal work in the US, especially in the US publicly funded home care system. So I want to start with, I think we all know that care, especially care activities between family members, is the most classical example of unpaid and invisible labor, or the quintessential legal non-work. Legal scholars have well documented the consequences of coming from the fact that care is not seen as a paid work, and this includes the court do not consistently enforce intra-family member contract where care is being transacted, finding care not to be an economic consideration when it's happening between family members. This also induced public policies not to fund care sufficiently, assuming family can internalize the cost of providing it. Meanwhile, we also know that care is actually not cost-free for people who perform it. There is abundant social science and public health research showing that providing care, especially long-term, negatively impact caregivers' job prospects, their economic well-being, as well as their long-term health. As women are more likely to perform care than men, and as low-income families are more likely to rely on non-market care because they cannot afford purchasing it from the market, this non-work status of family caregiving also has resulted in various dynamic of inequalities. In response, this has been a huge concern for feminists, and there's various feminist political proposals about how to value care, how to make care visible, ranging from proposing to accounting for family caregiving in the GDP calculation, to the probably the most famous political proposal, Wage for Housework campaign in the 1970s, led by a group of socialist feminists both in Europe and the US. However, a lot of these feminist proposals remain theoretical and exploratory, since the unpaid status of family caregiving just seemingly blocked the law from possibly see it as work. There's also a technical question here. If there isn't a market price, what value do we put on family caregiving? How much do we say the work of family caregiving should be paid for? And today I want to share with you that some recent development in the healthcare policies in the US that has indeed transformed a part of this activity of family caregiving into legal work. So this we have to go back to the healthcare policies, and I want to just briefly introduce, this is mostly happening under a program called Medicaid. So Medicaid is the means-tested public healthcare insurance program primarily targeting low-income households. According to the Medicaid, the federal statute authorizing Medicaid, it mandatory cover nursing home care for individuals with disabilities who would need assistance to live independently. Since the late 1990s, there is a recent move to move a lot of individuals with disabilities out of nursing homes into home care. And there are two major arguments for this move. One is that there is a Supreme Court holding in 1999 finding it is indeed a disability right to community integration. So individuals with disabilities has a right to live in their community rather than being put in the institution. Second, and probably more meaningfully for a lot of Medicaid program management, the argument is that home-based care is actually cheaper. It provides a more budget-friendly alternative to care institutions. As more care is moving back into homes, and over the past decade, state Medicaid programs had made a second development, which is starting to establish various consumer-directed home care programs. In these programs, the law allows the care recipient to choose the care provider who provides the personal care assistance to them in their homes. And in most of the cases, the individual with disabilities chose a friend or family. So it's through a chain of, like, home care is cheaper than nursing home. Family care is actually cheaper than the market home care provider. This gives rise to a surprisingly large class of public paid family caregivers who are, for somewhat, wage laborers for some part of their time. So a recent AARP report estimates that in the year of 2024, there are around 10 million family caregivers in the US who receive some payment from the government for the care they provide. Of course, this is a Medicaid program, and it's subject to all of the political contingencies happening to Medicaid, as we've witnessed under the current administration. But for me, my research question, I think it's from a different version of the slides I provided, but I think I can make it work. So my research question into this new regime is mostly a how question. How does this once invisible, unpaid, and non-work like status of family caregiving transform into legal work in this system? What is the new boundary between work and non-work that healthcare law in combination with labor law generates under this new regime? And for my methodology, I looked at primarily at the New York State's program. As US is a federalist system, there are at least 50 different Medicaid systems, and this is the New York story. And I picked the New York partially because I live there, but the other reason is that it's the second largest home care system in the US, just behind California. Its CDPAP program serves between 200 to 280,000 elders and individuals with disabilities, so it's quite a sizable program. And for my case study, I collect a range of data, including administrative law disputes, where the welfare recipients coming to the state arguing for longer coverage of their care. I also looked at regulations, case laws, and I conducted background interviews with various activists and community leaders in this program. So, how does this work? This is the structure of the public-private mix of the CDPAP program. The federal and state government together funds this entire program, and as part of the public-private collaboration initiative, the state government outsourced the management of this system to a managed care plan, which is basically a for-profit health care company. So when a Medicaid recipient come into the system asking for the state to provide care, this managed care plan will send an independent nurse assessor into the home, try to come up with a document documenting how much service this person would need in order to live independently in their home. And this process generates this document called the care plan. The care plan determines the maximum hours of services that the state has a duty to provide to the individuals inside the homes, and also this becomes the maximum hour that the insurance company would authorize payment to the care worker. Then the recipient with this care plan find a direct care worker, and in this case, very often a family member. And then in addition to the paid dimension of this system, there's still a lot of family members like that's somewhat contributing to the care, but is not paid to make care work. And so overall, I find there is a turn to medicalization, turn to the healthcare system in how to generate value, how to assess value of family caregiving. And there are three dimensions of it. First is who. There is a turn to nurse assessors, turn to physicians, like lawyers and judges handing over authorities to doctors in telling what is valuable work, what is non-work. And second, there is a turn to medical expertise and medical expert-generated indexes and metrics in valuing which part of care arrangement is work and which part of this arrangement is not work. And the third dimension of it is that this is all done through a clinical evaluation system. This is done as part of the medical treatment, but it also has legal significance in generating this new boundary between work and non-work. And I want to show you how this works through a real example from the fair hearing record I've collected. So this is a real story of care. Grace is an 82-year-old New York State resident who was diagnosed with Alzheimer's and a lot of other symptoms, so she's been qualified for nursing home level care. Grace lives with her daughter, who works outside home from 10 a.m. to 7 p.m. every day, and Grace hires her niece as the personal assistant through the Medicaid program that I just described. The niece will come every morning when the daughter leaves for home. The niece will help the Grace to get out of bed, prepares her meal, encourage her to eat and drink fluids, and assist her to take shower and go to bathroom as needed. In addition, the niece also will just stay with her until the daughter comes home. That during this time, she will make sure that the Grace does not fall, she does not leave the stove on, she does not lock out other family members, and does not wander off from the home. And when the daughter comes home around 7 or 8, the two will get Grace ready for bed together, and the daughter will respond to Grace's need during nighttime. In addition, Grace has a grandson who will sometimes drive her to doctor appointments, and sometimes stay with her. So this is a care arrangement. It's very typical to individual needing care at home. And you may ask yourself intuitively, okay, this is the arrangement, which part of it is work? Which part should the law see as wage labor, and which part is not? And through my research, what I'm showing is how the state, how the government practice this boundary drawing practice. So according to the Medicaid regulation, the state will look at this arrangement through a list of tasks that gerontologists, medical professionals, has said they're essential to independent living. This is called assistant daily living and instrumental assistant daily living indexes. Includes a list of tasks such as bathing, dressing, toileting, transferring, and eating. And then there's a second line of the regulation says that none of the tasks, if somebody is willing to do it voluntarily, willing to do it free, none of it should make it to the care plan. So how it works in reality is the nurse assessor comes into the home, they talk with Grace, they talk with the caregivers in the arrangement, then they look at this care arrangement and put what's in red here as the medical tasks that is needed, such as getting the patient out of bed, preparing meal for them, and encourage her to eat and drink fluids. All these are on the list of medical indexes, and this comes down to the care plan that the nurse has made through this clinical procedure. And what's here in the story, but in blue, is the part where either the nurse says that there's no medical value. This is not what a medical expert has said is essential for independent living, or it's something that one of the family members is willing to do for free. So with the task here that's in blue has not made to the care plan, and instead has become part of the natural support dimension, or what is remained unpaid non-work. So, and this does not only have healthcare significance, but also has labor law significance. So in 2015, the Department of Labor, which is the U.S. Labor Enforcement Department, has issued a regulatory notice drawing the boundary of care, boundary of work in scenario like this. So this regulatory guidebook has stipulated that for Fair Labor Standards Act, which is the U.S. Wage and hour protection, it only covers the tasks that appear in the care plan or what the nurse has put in red, and while what's left is what the department called a natural support relationship that has no labor protection or work recognition. So in other words, like this red, blue, like exercise was not a boundary drawing practice for healthcare in determining what is fundable and what is not. It's also a boundary drawing exercise for labor law in redefining what is work and what is non-work in the case of public paid family caregiving. So this task vision of what is work in the care scenario not only impacts what the Department of Labor says is work, it also impacts how the wage boundary is enforced on the ground. So in 2016, there is a federal legislation mandate the furnishing of electronic visit verification system for publicly paid home care programs. Under this law, before the state issues each payment for the care provided, the caregiver need to verify, usually on a mobile phone software, and the verification includes that they need to verify that this individual was indeed eligible for care service, that the task the caregiver performed is included in the care plan made by the medical professionals, and the task was indeed provided. And in implementation, this often involves GPS pinning to make sure that the caregiver is on the work site, and also sometimes includes in the requirement for the caregiver to upload photos or videos of the care recipients just to prove that the care is provided. So I think in yesterday's plenary, there was talking about surveillance and monitoring, and this is how monitoring surveillance coming to the home workplace. In addition to the wage and hour rights, so this recognition or this partial recognition of family caregivers as workers has also given rise to organizing collective bargaining rights. So in 10 states currently in the US, the workers, the paid family caregivers that I am describing did get organizing rights through the state public sector labor law, and there are unions representing thousands of home care workers, over half of them family caregivers. But in addition to wage and hour rights and organizing rights, other parts of labor protection, such as anti-discrimination, and especially like occupational safety and health, whether they have rights or how the rights should be enforced, is much more of a question that's vague and we don't know yet. So far, I've been talking about the empirical dimension. I've been describing how the system works. What is the normative takeaway? How do we see this system? Is it a story as valuing care, or is it a story of disvaluing care or undervaluing care? So I think it's very much glass half full, glass half empty situation. On the one hand, like the turn to medicalization, the turn to medical evaluation does give us some legible tool to make care visible, or to make at least some part of care visible. And by making it visible, it also making it fundable for the state. The state has a device to say, okay, how much value is family caregiving generating and how much we can pay for it. And this is meaningful, especially because how invisible, how hidden family caregiving as an economic relationship has been so far. But I think this is also very much a story of undervaluing care. Like when we are looking at the holistic care process and just cutting it into a set of tasks and saying, okay, this set of tasks is work, it has health value, while the other set of tasks is, I don't know, whatever left in the family relationship. This practice of cutting care into modular units and also like enforcing this boundary through a highly intrusive surveillance mechanism, I think it loses the whole picture of care, loses the relational value and the relational dimension care, where we want to see the person we care for as a holistic person instead of a combination of just tasks. And also, this system, as I told you, still continue to heavily rely on unpaid care and relying on the non-work performed by family members voluntarily. And so there is a dimension that this system would not work. Home care would not be cheaper than nursing home care, but for the continuous existence of invisible labor. So this is still very much a story that care is somewhat valued, but not exactly, where the family caregiving has partially become work, but not the entire relationship. So that's the end of my presentation, and I very much look forward to the discussions.
Well, after this fantastic case study, we also look forward to the discussion. And as you can imagine, for a person in my age, this is close to my heart, you know. But for the discussion, we should reflect whether the fact that these people have been invisible so far is not by accident. You know, there are many factors. Last not least, they have no power. And since they have no power, I'm still asking myself whether the kind of improvements you have in mind do have a realistic chance, in particular in the present context of the United States. Okay, now it's Professor Elevet, Anja Elevet, from the Free University of Amsterdam, and she will talk about meaningful work and the legal underpinning of activation and conditionality. Go ahead, Anja.
So thank you very much. Thank you very much for inviting me at this beautiful conference. And because also it gives me the opportunity to talk about my favorite subject, mandatory work for social assistance recipients. So let's first ask two questions.
Is the microphone
Is the
working?
microphone on? Yes. So first, two questions. Mandatory work performed by social assistance recipients, is that work or is that non-work? So I'm going to answer my questions. Yes, I think it's work because people, social assistance recipients who who are obliged to perform work in their activation programs usually perform similar work as employees do. Only the difference is that they are not covered by labor law and social security law. And a second question, why is work important to people? Well, there has been a lot of research on that, and it's mostly important for people because it helps people to develop themselves. It's useful, it's a source of recognition, it's a source of social interaction. So yes, work is important to people, it's meaningful to people. But can mandatory work also be meaningful to people, when people are obliged to perform work? So that's a question I was struggling with. But let's first have a look at the legal framework in the Netherlands. We have the Participation Act, so that is social assistance legislation. And there we find the obligation to participate in activation programs. And this obligation is imposed on all social assistance recipients. Only people who are 100% incapacitated are exempted from this obligation. It is implemented by municipalities, and not all municipalities are equal strict, but if they implement this obligation, then if people don't comply, their benefits will be reduced with 100% during a month. And the policy officer also does not have discretionary space to, not to implement this, or to not impose this sanction. But there is also a hardship clause in the Dutch Participation Act. And this means that when you apply this hardship clause, then the sanction can be reduced. But as my research on case law shows, the court hardly never imposes or uses this hardship clause. And to my mind, this is not this is not allowed under the European Social Charter, but I won't talk about this because I don't have much time. Okay, but the question was, can mandatory work be meaningful work? Well, if you look at previous quantitative research on participants in mandatory work programs, then we see that they report relatively high levels of well-being and also high levels of life satisfaction. Their autonomy is restricted. So the question is, how is it possible? Because autonomy is a basic psychological need that positively affects people's well-being, according to a famous research by Ryan and Deci. So how can mandatory work be meaningful? So I carried out a qualitative study, and the aim of this study was to provide more insight into the interaction between welfare recipients' constrained autonomy and the way in which they experience mandatory work as meaningful work. And there are some differences between the previous quantitative studies. First of all, this is a qualitative study. Second, this study is only about social assistance recipients, whereas the other studies were mostly about beneficiaries of unemployment benefits, and those welfare recipients are often more closely to the labor market. And also, my study only included programs where people had to learn basic working skills. So it did not include training programs. So what it did include was learning people to listen to a boss, to be on time at their work. So it was about people working in gardens, people working in a production, people working, picking up litter from the streets, people working in the hospitality sector, most of all work which did not require any skill or not much skills. So my theoretical framework is based on Marxist approaches and Aristotelian approaches. Because I don't have a lot of time, I will only focus on the Aristotelian approach very briefly. And this is based on the work by Andrea Feldman, who, based on her Aristotelian perspective, she's a philosopher. She says, work enables people to develop their capacity for agency and as such also to flourish. Well, people familiar with Aristotle know that flourishing is a key word, a buzzword in his theory. But there are also some conditions for meaningful work, also on this Aristotelian approach, namely there has to be some autonomy. And Feldman distinguishes between 3 dimensions of autonomy: autonomy within work, autonomous choice of work, and autonomy as economic independence. And I think the first 2 dimensions of autonomy speak for themselves. The third, I may need to explain it a little bit. Imagine a precarious worker who is highly dependent financially dependent on his or her employer, well, he or she might also be exploited because there is no other choice than performing this work. So that's when you have more economic independence, you will not be placed at the will of the employer, or have less chances of being placed at the will of the employer. So now let's apply those 3 dimensions of autonomy to mandatory work programs. Well, autonomous choice of work. Well, this can be restricted if people don't have a choice to participate in a specific work program. And it's restricted because they will receive a financial sanction. Well, what about autonomy as economic independence? Well, this is also restricted because if they leave the entire situation, they will not have any financial means to sustain themselves. So there's no exit option for them. So this is also very much restricted. And the autonomy within work, well, that will depend on the type of activity they will have to perform. Well, let's now go to my findings. So I interviewed 42 welfare recipients participating in mandatory work programs. And on the one hand, well, part of them experienced their work as meaningful work. They felt useful, they enjoyed the social context they had. They said, well, I'm really being seen by other people, and it also helps to develop myself. So these were experiences of meaningful work. And I also have here an excerpt of one interview with Jeroen. And he was doing work in a second-hand shop, and he said in this interview, which really illustrates how work can be meaningful, I'm happy to be working again. I'm among people. I like to help customers. They come to me asking questions, and sometimes I'm able to help them, and sometimes not. I feel that I'm meaningful for society. I'm not only sitting at home, alone, a loner. I am someone. I can be myself again. I can do things, have a drink with colleagues. That's fun. You are connecting with new people, and the best thing of all is that you can simply be human and be yourself. So this really expresses, I would say, all kinds of dimensions of meaningful work. And the dimensions I found also really reflect what is found in the literature on meaningful work, but which is not on social assistance recipients, but work in general. But also a lot of participants experienced their work as meaningless. So they said, it does not contribute to my personal development. They were bored in doing this work, and they also felt, and that's most important, they also felt they were not being treated with dignity. So an example here in the excerpt of the interview with Glenda. Glenda was working at a production site, and she had to fold washcloths, so that's things you can wash yourself with. And she said, the boss said, you will have to do all the work that you are ordered to. And then she says, you have to do it. You have no choice. Those washcloths have been washed, but they are still dirty. There are some really disgusting things among them, and I would rather not sort them out, but it has to be done. I was against it in the beginning, but I have to do it, so I do it. You must show that you do not come here for nothing. So what this shows, and especially later in the interview, she says, well, if I would have received payment for the same work, it would be fine. It would be acceptable to me. So what this shows that it was really her position as a welfare recipient which made her feel like losing dignity and self-esteem by doing this dirty work. Yes, and then also, how is meaningful work or meaningless work related with autonomy? Well, what I saw in the interviews was that work became more meaningful when people had more space to decide what to do within this work, and also when they had more choice in the type of work program they could choose. But what I also noted that a lot of people who expressed feelings like, well, this work is, I really like the work, etc., were also people who were aged over 50 and who had very little chances on the labor market. And I interpreted this outcome also as adaptive preferences, because for them, well, doing this work in this context was maybe the best thing that was the best option they had. And then about people who experienced the work as less meaningful. Well, first of all, people who were in disciplinary programs. These were people who had to pick up paper from the street. They didn't learn anything of it, I guess, but they had to do it. It was a kind of a punishment, and they also had very little space to decide what to do. So here you also see the relation with autonomy. But also people who experienced a lack of perspective to paid work. Well, eventually all people experience a lack of perspective to move to paid work, but especially those who were very ambitious, who really wanted to move to paid work, they felt that their dignity, so that they felt a loss in dignity, and they also referred to this work as forced work. So, yeah, okay. So my conclusion is, mandatory work programs may lead to experiences of meaningful work. However, because of their status as welfare recipients, participants may experience a loss of dignity when they are required to perform mandatory work. And this is what I showed in the part of the interview with Glenda. And also the amount of autonomy affects the way in which recipients experience their work as either meaningful or meaningless. And here I also wanted to repeat again these adaptive preferences, which also which also played a role here. So regarding those conclusions, I was wondering, could we not think of alternatives for work programs in social assistance schemes, especially regarding the fact that they do not help people to move to paid work, and also regarding the adaptive preferences I mentioned, and also especially because of the lack of dignity that people experience by participating in those work programs. Well, I think an important point is that work is not the only source of meaningfulness. So you could also think of other activities which can make people's life more meaningful. And I think it would be an important thing that welfare recipients also have a say in deciding what kind of programs would be useful for them. But that's still not really happening. And then another point I want to raise, what is the role of law in all of this? Because what we saw also in the Participation Act, I just showed you that, well, it reproduces a dichotomy between the deserving and the undeserving poor. And this will also affect the way in which people look at welfare recipients, and also, well, contributes to the stigmatization of welfare recipients. And then I also thought, well, what could be the role of the court in all of this? Could the court break through this dichotomy? And I think, yes, they could do this, but in order to do this, the judges need to be able to put themselves in the position of the welfare recipient. And I guess that they often do not really have the tools, or it's very difficult for them to put themselves in the position of the welfare recipient. So what, let's see, yeah. So what would they need to do this? And my provocative advice would be to read more literature, because that perhaps would enable them to put themselves in the position of other people, such as welfare recipients, and to understand their perspectives, their vulnerabilities, their motives in a better way. And that would also then help them to interpret open norms, such as the hardship clause I mentioned. It helps them to interpret those norms in a more creative way. And probably that would in the end also affect legal discourses on welfare recipients and also the dominant social discourses on activation. So with that provocative comment, I would like to close this presentation. I'm very curious at your comments and questions. And if you want to read more, well, this was a summary of my paper published in Critical Social Policy. Thank you.
Thank you very much, Anja. Well, I join Anja with her, problems she has with the question of dignity, with this paternalistic approach, you know. This remains to be problematic, even if, let's say, the recipients might feel that this work they do is meaningful for them, you know. It's still not voluntarily chosen. And that's something I think we should look at. Okay, well, yeah, I see already a hand there. Do we have a microphone?
No, could they use the podium since we are live streamed?
Okay. So, do you want to come to the podium? It will take more time. That's a problem.
Yeah, I'll be quite quick. Okay, I had a question to put to Ms. Thang, and I was wondering if that holistic approach that she proposes would also include the lack of social contributions and tax payments that are not received by the government for the persons that are staying at home. The people who stay at home cannot go to work and therefore cannot contribute in economic terms. I guess there may be some studies that also make a relation between both things. Then I would like to put forward my disagreement with the realistic focus of the moderator, because I think if all we could discuss in last seminar are proposals that the legislator is ready to accept in 2025, then probably these seminars would not have any debate, or maybe today's legislation probably sounded unrealistic 5 years ago. So I think we have to open our minds and let thought and unrealistic proposals to flow.
I think there will be agreement, but I would like to collect some questions to make it possible that many people can intervene. Here is... What about the micro? I'm sorry, I chased you. There was somebody. No? Apparently hidden. Okay, go ahead. I'm sorry.
Hi, Urseta Cauda from the OECD. I had a question for Anja, so the last presentation. Just from a labor economist point of view, which is quite complementary to yours and find super interesting, do you know what portion of the inactive population is covered by the activation programs, or of how many people are we speaking about? Not that if they are too few, they are not important, but just to have a magnitude, an order of magnitude. And so I understand correctly, these people are out of the labor force. So these people are not officially searching for a job, or are they? And in that respect, how does it compare with the unemployment benefits / activation programs for the job seekers? And an additional related question is, in your research, have you found that the Netherlands is a very odd example in that respect, or is this kind of policy widespread in other, let's say, comparable European countries, not to speak about like US, or just from a labor market point of view, I would be very interested in learning about this. Thank you very much.
If in the moment, if there is no other question, I have a question for Luz. Luz, you told us that it's important to have the possibilities of the workers' representatives in the context of algorithmic management. I'm asking myself whether, again, this is not an unrealistic approach, because I'm not sure whether the workers' representatives, and by the way, the same applies for the employers, are really able to understand what's going on. So I'm asking myself whether we are not creating a sort of alibi context, which might look nice, but not help very much. Okay, so I would say start with the answers. You start.
Sure, I can start. Thank you for the question. So I think what you're asking about is like a perpetuating question, like related to public systems or to anything public. It's like, who is deserving the service, who's deserving the right, and when do we see somebody contributing to society and what group we are seeing as not contributing to the society. And there are two groups relevant here. One is the first is the group who receive care, and then there's the group who's providing care. So I think one dignitarian or one recognition dimension of the changes here is by changing at least some of the things that the second group is doing and bringing it into or on par with wage labor. So to some extent, it might change the perception of whether we see them as a contributing members to the society. But I think there is also, like, for the entire overarching system to really thrive, and I think we need to have a perception of contributing members of the society, or have a conceptualization of deservingness that's beyond just productivists or beyond people who are working and paying taxes.
Anya. Yes. Tanya.
Yes, okay, thank you for your question. Well, in the Netherlands there are about 400,000 people on social assistance benefits, but there are, so as I said, in principle everyone is required to participate in activation programs, but there are no real fit numbers about how many people are participating in those mandatory work programs, because you also have different kinds of activation programs. So honestly, I wouldn't be able to tell how many, yeah, so I won't, but well, I did research in 3 municipalities, and there it was common to send everyone who was able to a mandatory work program. Yes, and with unemployment benefits, well, first of all, as I said, those people are closer to the labor market, and they can be required to perform activities. Yeah, what is probation place? Something. Probation is not the right word, I guess. It's so they can work with keeping their employment benefits in a kind of workplace, but also in order to maybe to get a work contract there. And so it's really different, because it really helps them to move to paid work, and also there are more legal protections in that, and that also is something I really found fascinating, that recipients of unemployment benefits are more protected legally compared to social assistance beneficiaries if they are working in a kind of a mandatory work program. And you say, isn't it an old example? Well, no, it's in the Netherlands it's still there, but it's true that I think it's less. It has been less popular. It has become less popular than it was a few years ago, but it's still being used. It's also being used in Denmark. So it's being used, I think, mostly in the front runners of activation policies, because they started to use these kinds of policies also in the UK, but in the UK they changed it. So in the UK it's not there anymore. And also, I mean, in Germany you have the 1 Euro jobs, but I think they apply it less now, and it's also more like a well, it's not an employment contract. Well, I'm not sure about that, but so yes, it's there. But especially, and the Netherlands was also a front runner in activation policies, like Denmark, and there they created those kinds of programs. But I'm also interested in doing comparative research because my feeling is that in the countries who have implemented activation policies on a later stage. Have not implemented it in this way, but I think probably they will go this way as well, but maybe also not. So that's also something I want to do more research on. Yes.
Before I give you the floor, I just want to say, you know, that on the one hand, among the core labor rights of the International Labour Organization, we have the prohibition of forced labor. But we do not care when there are recipients of social assistance. We do not care when there are prisoners, you know. We have to think about this, you know. The way we try to divide people in a way that for all of a second, you know, the prohibition of forced labor is irrelevant, you know.
Yeah, but indeed there has been cases on whether those kinds of work violates the prohibition of forced labor, also in Article 4 of the European Court of Human Rights.
Yeah.
But the answer is no, and I do understand that.
Depends.
But we also have the right to freely chosen work, and I think that is a right which would be really interesting to apply this to the mandatory work programs. So.
Okay, Luz, it's your turn.
Okay, two questions or two debates. I think that as we are speaking about labor law,
yes,
and as labor lawyers, we can do two things. The first one is to say, here we have our laws, and we try to explain this law and to understand these laws. Yes, this is wonderful. But my point is different, because sometimes I think, okay, I'm a labor lawyer, and I have to see the new problems and try to understand the new problems in the labor market and try to answer or try to build an answer to this new problem. So I'm trying to answer what is the meaning of work and non-work in this period where technology is around us. This is my first point. So that's why I have been researching data protection as a labor right, and I have been researching how to use data GDPR as a labor tool. This is my last task in GDP powers. Second question. It's true that at this moment, European Union is changing because, as you know, we have this threat of omnibus regulation. Yes, it's true. But I think that we have, at this moment, two important tools. The first one is GDPR. I have been studying and I have been criticizing GDPR. But we have GDPR.
GDPR is supposed to be reduced by omnibus.
But not the principles of GDPR, but not the principles, and not the right of access. And this is the real important right, the right of access. And we have, the second point is the platform work directive. And we want to have a new directive, of course, because we think that algorithmic management is not only for platform workers, is for all kind of workers.
Yes.
But at least at this moment we have Platform Work Directive, and we have many tools to try to expand the right of workers, of course, but the representatives of workers and trade unions to try to understand this new way of exerting the employer power. This is my point. And finally, it's true that it is really difficult to understand algorithmic management, information about algorithms, about data, about artificial intelligence systems. It's really difficult. I tried, but it's really difficult. But at this moment, many trade unions around the European Union are training their representatives in every company to try to use and to try to understand data and algorithms as a tool for a new strategy to defend a new rights of workers. So, as a labor lawyer, I prefer my second point. We don't have a law, but we have to think how can we build a new law to try to maintain the final and the mainly goal of labor law, protecting the workers' rights. Okay?
I agree, you know, and I can tell you that in my country, in Germany, the Metal Workers Union, which is a huge trade union, they have just created a huge institute for AI and algorithmic management, you know. But the problem is, you know, we have this right of information in the directive. People, in particular employers of medium-sized companies, they tell me it's absolutely useless. We get these mechanisms from China. There we learn that it is facilitating our activities. That's all we want to know. We know nothing more. And now our workers have a right of information. What shall we tell them? We don't know anything about it, you know. This is ridiculous. This is ridiculous, you know. That's why I'm saying if we have these kind of rights, right of information, consultation, co-determination, whatever it is, we have to keep in mind how in practice we make it in a way that, well, it's something of power which is in the hands of the workers and not something alibi, you know. That's what I want to say. Okay, but I'm not monopolizing the discussion. Come on, don't fall asleep. Yeah. Where's the micro?
Yeah, thank you. My question will go to Fernandez. I really support the idea, and what I'm seeing, if I understand correctly, we know little about platforms, workers, and as I understand, we have only in Europe 3% of European population are working in platform work, right? And the speed of platform is not going at the same time as actually we are implementing something and we are bringing laws after. What do you think? Why everything is being implemented without laws?
Okay. Somebody else? Yeah, go ahead. Mike? Don't worry, you. Okay.
Also a question for Ms. Fernandez. Just again, as an economist, in terms of complementarities, I was a little bit curious about your first slides, one of your first slides, when you said you've done this survey on platform workers. You said, and so basically you've done a survey, because there is a debate in the literature in economics to define what, you know, a gig worker is, etc. And you conclude that most of them are men and high qualified. And, you know, this sounds strange to me. One think about the Uber, the Deliveroo, etc. So is it just because we see so many Ubers and Deliveroos, but then most of gig workers are just doing something else? Or is it a lot of cross-country heterogeneity, because I believe these are average data? So I was kind of curious about that aspect, because it also has implications, of course, for workers' bargaining rights, for their, you know, their capacity to defend themselves in a sort and understand what's going on. Thank you.
Yeah. Lady here.
Thank you very much for Fernandez. A little comment. I think the main idea or the main concept could be the governance of algorithms. And this is a problem in different topics of our society now, but in law it is to this problem, the governance of algorithms. And for Elevelt, I think a useful concept could be Virginia Mantovalu. Do you know Virginia Mantovalu? She's a researcher of UCL University, and she researched about your topics of it's very nice. I like it very much, and she talks about a very suggestive and interesting concept, I think, and it is the structural injustice mediated by the state. No, that's all.
Okay. Now you have 4 minutes for answering all the questions. Well, yeah, sorry.
Yes, so I know her work, and I also know her theory on structural injustice. Yes, so thank you for remembering me. Yeah.
Yes, I begin with the data. In every survey about platform workers, as you know, this is a main figure, the high-level education of platform workers. Why? Because we only see delivery platforms workers and taxi platform workers. But as you know, we have many other platform workers around the world in online world. So we are speaking about all the figure of the online platform workers, programmers, I don't know. So this is a main figure of platform workers. And for example, in Spain, in France, in Germany, many workers with high level of education in the origin countries, because they are migrant, they have a high level of education, and they are working in platform work because this is the first task, the first job he or she finds when they arrive European Union. So they have a high level of education, but we have these poor and precarious jobs. This is a main figure of education. And after that implementation of this kind of law, you ask me about implementation, about this law, this kind of laws.
Actually, platform workers' jobs are coming at rapid speed, but the laws are coming after.
Slowly.
Okay. It's always the same. I think that labor law go after the new problems and the new situations of labor market. We can advance the problems. We can advance the situations. We are seeing the reality, and we can see the problem, the new problem of labor market, and we try to put a law in this area. But in this case, in platform work, we have many legislative initiatives in many countries around the world that which demonstrates that law is going with the problems with the platform workers. For the first time, I think so. Law is going with platform work, law is going with platform workers, and we have, at this moment, more than 25 new laws around the world about platform workers, and we have one European legislation, but we maybe will have a new convention in the International Labour Organization for the first time after only 6 or 7 years after the platform work is here. So I think in this case, law is going with the platform workers and law is going with the technological change.
Okay, thank you very much. Thank you for your questions and your comments. Thank you for your attendance. And in particular, I would like to thank my 3 speakers who were wonderful. First of all, they all kept the time, which I appreciate very much, you know. And secondly, you know, you have seen they have put us and shown us problems where we have more open questions than answers. And of course, I would say the question raised by you, whether this kind of, how should I say, informal work can be transferred into a formal structure. I would say this is the crucial question of our time. We have so much informal work in the world, much more than formal work. And the ILO for a certain time had the naive idea, and they put it in a line which was ridiculous. Formalization of the informal work. Not understanding that what we have as formal work is European-centric, looking at our culture, looking at the binary structures of our employment relationships, and so on and so on. It doesn't fit in most areas of the world. I can tell you, I have worked in Asia, I have worked in Africa, I have worked in Latin America. The world looks totally different, you know. If you go there, and then you have to ask, what kind of rules do we have to apply? And certainly, it will not be the same rules as we had so far in labor law. This is the task of the future, not of my time. My time is over. But for you, young people, you have to resolve these kind of problems, you know. Thanks again for your interesting speeches. And now I think we all have deserved lunch.